All right. Sorry I'm a little bit late here, but we have Blake Lively's reply in support of her motion for damages under 47.1. Now, if you guys don't remember, 47.1 in California is this thing that people will refer to as the Me Too law. She's asking for treble damages and all kinds of shit that she thinks that she is entitled to, even though she has not actually proved or shown any evidence of any sort of sexual harassment or like shown that she had a reasonable basis to bring these claims and that they were made without malice. So she's arguing that she should not have to do that. That basically these damages are supposed to be awarded basically like as soon as possible in the earlier stages. And it's kind of ridiculous, and we'll go through it. It's only 10 pages of the actual filing, so this is not going to be a super long one. I just wanted to go through it a couple times before I came on here because I was like, I'm surely this is not what I think it means because that would be incredibly stupid. But no, it is. It means what I thought it means. So I don't. I'm kind of losing new ways to say what I feel about this. I think Blake Lively's ego is it's like a balloon at a kid's birthday party. It's loud if it pops. It's fragile and it's full of hot air. And her head is so far up her ass her thoughts are echoing at this point. And I think that's what's contributing to her kind of pushing her attorneys or signing off on this. Like it's, oh my God. She's the kind of person who would hold a press conference about what a humble victim she is. So I'm just kind of like at a loss for words sometimes when I'm reading this stuff. But all right, let's just go through this really quickly. We won't have to read it word for word because a lot of it is rehashing of their initial arguments, which were not good, by the way. But nonetheless. Okay. All right. The Wayfarer parties brought a meritless defamation action in New York under California law using California based attorneys representing a California company based in large part on a complaint. Ms. Lively filed with the California Civil Rights Department. The court dismissed the Wayfarer parties' lawsuit against Ms. Lively, including their defamation claim and every other claim they alleged. They now seek to repudiate their invocation of California law to avoid the consequences of their failed litigation strategy. They advance 3 arguments for why the court cannot or should not rule on Ms. Lively's motion, all of which fail. And if this actually did work out in her favor at this stage in all of this, that would be insane. Absolutely insane and unjust. So, hang on one sec. Emphasize every time they use the word intent. Okay. Well, I'll look out for it. Let's see. First, the Wayfarer party suggests that this court cannot rule on Ms. Lively's motion because it presents issues of first impression under Section 47.1, including ill-defined constitutional concerns and conflicts. Lots of people have said that. Most people, I feel like, who work in the legal field that I've talked to have said that. I know Omar and I talked about this the other day. And then, asked 2 lawyers, a couple of friends of ours, they, had different opinions about that. I haven't heard from them, though, in a little bit, so I'll have to see what's going on with those guys. It's always good to get other opinions, so. It goes without saying that this court has the authority to rule on matters of first impression, including Ms. Lively's motion, especially when, as here, the Wayfarer party's own claims and litigation conduct before this court have put Section 47.1 at issue. No. No. Okay, so you can't just say that and make it true. You don't just say that and people automatically have to believe what you're saying. So that's the thing about this. So we're just supposed to take your word for it? Anyone who accuses anyone of some crazy bullshit can get away with that? Like that's insane. There has to at least be a standard here. All right. Nor does the Wayfarer party's free speech arguments under the Norr-Pennington Doctrine and California's litigation privilege change this. No, of course, because that only applies to Blake, right? As the Second Circuit has not decided whether Norr-Pennington even extends to non-commercial litigation, and the canons of statutory construction compel the conclusion that Section 47.1 carves out an exception to California's statutory litigation privilege. All right. Second, the Wayfarer party's argument that Section 47.1 does not apply extraterritorially, where Ms. Lively is not a California resident and the film was shot outside California, is similarly meritless. None of the Wayfarer party's case law addresses application of a state's law when the party resisting application itself brought claims under that state's law. Even if they did not invite application of Section 47.1 upon themselves, which they did, and again, no. There's literally nothing has been shown to give it a reasonable basis for believing that. Okay. there exists a sufficient nexus between California and the Wayfarer party's retaliatory defamation action based on Miss Lively's California CRD complaint, the only conduct relevant here to justify its application. I don't think that's the only conduct relevant here, but okay. Third, and this is the one that is like, I couldn't believe what I was reading. I think it was the third one. Let me see. Yeah, this is the one. Okay. The Wayfarer parties argue that the court cannot apply Section 47.1 without factual findings, that Miss Lively acted without malice and had a reasonable basis to make her complaints about harassment and retaliation. That is an extremely reasonable standard for these kinds of damages. This is insane. In effect, the Wayfarer parties argue that the court cannot conclude that Miss Lively is the prevailing defendant in the defamation action, which has now been dismissed with prejudice or abandoned in its entirety. Instead, they argue Miss Lively must endure a jury trial to prove that she already prevailed. No, she just has to prove that she acted without malice and that there was actually a reasonable basis for her to bring these claims of sexual harassment. It doesn't mean their claims weren't dismissed. It doesn't mean they didn't have any pleading deficiencies. It just means, like, she has to show that there was actually a reason for her to bring these claims in order for her to be awarded these huge damages. I feel like that makes sense. But no, of course, they say this makes no sense and runs counter to the California legislature's express intent to provide remedies to a successful defendant at the earliest stage, typically through a motion to dismiss. That is insane if applied here. In a perverse twist, do you want to talk about a perverse twist really quickly? Because I would argue that a perverse twist is saying that a still photo of a home birth is pornography. But hey, if that's your thing. In a perverse twist, the Wayfarer parties attempt to justify the exact type of protracted litigation the statute was designed to curb by arguing that Miss Lively's affirmative claims, with which the Wayfarer parties' separate lawsuit had been previously consolidated, present the same factual issues as her motion under Section 47.1, and thus must be decided together to avoid inconsistent rulings. So what if they were to here award her these damages, and then later at trial, they find that she did not have a reasonable basis to bring these claims, she did not, or she did act with malice, or she did not, bring these claims in good faith. So that would be inconsistent. Then what do you do? That's a pretty, I think that's an issue that should be addressed. All right. Miss Lively's claims do not necessitate Miss Lively to prove that she acted without malice. Yikes. The Wayfarer parties did not allege otherwise in their lawsuit and should not benefit from the fact that Miss Lively's affirmative claims remain standing. So not only, they shouldn't have to prove that she acted without malice, but also it doesn't matter that her claims haven't been proven yet. With this affirmative claims remain standing, they haven't actually shown anything yet in court. No trier of fact has found that there was any reasonable basis for these sexual harassment claims or that anything was actually done wrong. This is insane. This is a nut house. I mean, Jesus Christ. This lady's brain, it's like a confetti cannon going off in a library. And who do you think signed off on this one? I'll give you one guess. No, I won't spoil it. Finally, the Wayfarer parties argued that Miss Lively has not established a basis upon which the court can calculate treble damages and cannot establish her right to punitive damages absent a factual finding from a jury. Not so. Miss Lively has already requested a schedule to introduce evidence of her actual damages, which will be established by the close of expert discovery on November 14th, and which the court can then treble. Moreover, California precedent confirms that a judge may award punitive damage under California Civil Code Section 3492. Indeed, that authority should apply with greater force where, as here, the malicious, oppressive, or fraudulent conduct is the Wayfarer party's litigation conduct, which is evident on the court's own docket. Shut the fuck up. I'm so sick to death of hearing about that. And so we had this conversation a couple times. And, some people won't hear it because I did a lot of lives, but where, Omar was asking me, what do you think about, the judge is always, when she goes and says they're acting inappropriately or whatever, the judge acts in her favor. And I've always said, well, they don't go to the judge and ask for the same thing on the other side. Right? So that, I don't know, that is just especially annoying to me because I'm both sides are kind of playing it in a way here that is sometimes kind of like, I wouldn't have done that, but okay. I wouldn't have asked my attorney to do that. I don't think that was a great idea, but both sides have done that. But only one side is like crying to the teacher every time it happens. So like when they're making it sound like they have been like acting in such a terrible way, I'm just kind of like, well, you've been doing the same shit. It's just you don't get snitched on every time, you do something they don't like. So, all right. The Wayfarer party should not be permitted to avoid the consequences of their retaliatory litigation tactics any longer. Nobody ever found that they did a retaliatory lawsuit. Like, that was not anything that was actually proven. So, go fuck yourself. I don't even know what else to say to that. The court can and should rule on Miss Lively's motion at this juncture and set an evidentiary hearing to establish Miss Lively's attorney's fees and damages. The Wayfarer party's suggestion that it is somehow improper for this court to rule on Miss Lively's motion, since California courts have yet to interpret Section 47.1, is incorrect. Good luck with that. This court is plainly empowered to interpret Section 47.1, where the Wayfarer party's own litigation conduct implicated it, and the court expressly allowed Miss Lively to renew her arguments thereunder. I don't think that their litigation conduct implicated it. I don't think that's true. I'm not a lawyer. We'll have to ask someone else, but you have to remember, this is a celebrity court case in which, the public opinion standpoint is very important here, especially as it's, going on and on, even when things are quiet with the court case. Like, what happens in the public eye is important. So, I don't know. This was a misfire to me, but we're not done yet, so... This court is plainly empowered, blah, blah, blah. If the Wayfarer parties did not want to face the consequences of California law, they should not have invoked it in the first place, and on multiple occasions thereafter. The Wayfarer parties also assert that this court cannot rule on Miss Lively's motion because it presents issues of first impression, including constitutional concerns and conflicts. Specifically, they argue that Section 47.1 infringes upon their First Amendment right to bring unsuccessful claims under the Norr-Pennington Doctrine and California's litigation privilege. Both arguments fail. Okay. The Wayfarer party's Norr-Pennington challenge, bare bones as it is, fails to raise free speech concerns. That is not true. Okay. A court in this district rejected a similar challenge, noting the Supreme Court's caution that the PRE standard, what is that again? I don't know what that is. I'm sorry. Is a doctrine of antitrust law, and that its holding is firmly grounded in the text of the Sherman Act in the context of antitrust liability. That's something we're going to have to ask Omar about. I'm not fucking with that. All right. The Second Circuit has not decided whether Norr-Pennington even extends to non-commercial litigation. And even if it did, it would not extend to Section 47.1, which itself exists to protect First Amendment protected conduct. Okay. Further, a defamation claim is not itself a constitutional right. The elements and scope of the claim may be limited by common or statutory law, as discussed further below. Moreover, any risk that Section 47.1's treble damages provision would chill petitioning activity in the form of defamation suits is outweighed by the risk, recognized by the California legislature, that retaliatory defamation suits would chill reports about sexual harassment. Well, you know what else is going to chill reports about sexual harassment? If this lady is successful in this, and then people come to find out at the actual trial that her claims were not brought in good faith. So if they were to award these damages now and to later find out that Blake Lively doesn't actually have any evidence of sexual harassment, which she does not appear to have, she didn't have anything to support her arguments in the initial motion here, except that someone on an unrelated project said they had vague, negative experiences with Justin Baldoni. Nothing about sexual harassment, nothing about the movie It Ends With Us, or anything that happened on set. That's a little chilling, don't you think? For her to embarrass people who need the protections of this law that way? But all right. And finally, even if Norr-Pennington applied to Section 47.1, the Wayfarer party's case would fall under an extension of the sham exception. Okay. As a baseless abuse of judicial process. Hey, let's talk about Van Zandt. No? You want to talk about a sham exception and a baseless abuse of judicial process? I mean, that wasn't judicial process. It was just legal process. But they didn't ever sign a judge to that case. So I don't know. I'm still mad about that. But of course. The Wayfarer party's argument under California's litigation privilege is equally deficient. I don't think so, but all right, we'll skim through that. I think that's kind of stupid. Nor is Section 47.1 an outlier. California courts have long carved out exceptions where the privilege would otherwise shield wrongful conduct. For example, as the Wayfarer party's own authority confirms, California recognizes an exception for malicious prosecution claims. Okay. This is because California's policy of encouraging free access to the courts that underlies the absolute privilege applicable in defamation actions is outweighed by the policy of affording redress for individual wrongs. Okay. The same reasoning applies here. The legislature enacted 47.1 to protect victims and to remedy the financial and psychological costs of litigation. And it would be such a disappointment if the first test of this law was wasted on this lady, who I believe is lying. So I gotta tell you, I'm not psyched about that. Okay. In any event, many of the public communications on which Ms. Lively's motion relies are not privileged at all, including, for example, Sorowitz's and Friedman's out-of-court statements. For the litigation privilege to apply, a communication must bear a functional connection to the litigation, i.e., the communication must function as a necessary or useful step in the litigation process and must serve its purposes, and cannot merely advance parallel interests, such as vindication in the court of public opinion. Okay, well, you had no problem with that. So again, I don't want to hear this bullshit from this lady who did what she did, abusing the legal system to get people's communications without giving them the opportunity to try to quash the subpoena that they sent to Stephanie Jones under some shady shell company and pretended that they were filing against John Doe's, right? So I don't want to hear from her about that. Jesus Christ. Vindication in the court of public opinion. I mean, she went through all of that to get those text messages, and then she went to the New York Times and did all kinds of shady shit. I don't want to hear it. I'm not receptive to that. Accordingly, courts consistently hold that certain public statements, like those addressed in Ms. Lively's motion, fall outside the privilege. And there's, again, been plenty, from the other side in the press that's been pointed out as to why they made those statements in the press to defend their clients. Like every statement that he made, that Brian Friedman made, that came out and they said that he was, they should sanction him for, he had the receipts to pull to say, like, this is why I said this. This was I was giving a response to this statement, which was unfair. And I needed to defend my client. So I don't know how that's going to go. Honestly, I don't know how the sanctions motion is going to work out. But at the same time, it doesn't seem like it was totally baseless and random to me. It's not like they just went out there and started berating her in the press. She said a whole bunch of shit first. All right. Finally, the Wayfarer party's assertion that a jury must determine malice under Section 47.1 fails, and that is ridiculous. Even if that's true, that's ridiculous. Where the facts are undisputed, as they are here given Miss Lively is undeniably the prevailing defendant in the failed defamation action, the applicability of a privilege is a question of law. Okay. Moreover, the Wayfarer parties identified no reason the court could not decide the issue sitting as the trier of fact. What? Jesus Christ. There's a pending trial. Like, what are you talking about? All right. The Wayfarer party's extraterritoriality argument is meritless. I don't agree with this. So I just asked Omar about this briefly before I started. So I'm not going to read too much into this. I will say that I don't think that is accurate. But, we'll have to talk about that more in depth when he's around so that he can kind of explain that in a way that makes more sense. We'll skim over a little bit of it. So they should not apply Section 47.1 or 3294 because Miss Lively is a resident of New York and the underlying conduct occurred in New York. All right. None of the cases cited by Wayfarer address application of a state's law that the party opposing application itself invoked. Okay. Yeah, see, I don't really know that matters. So, like I said, I want to go over that with somebody who knows more about what they're talking about there. Because to me, it doesn't make sense, but that doesn't really necessarily mean that there's no circumstances under which that could be true. So, even if the presumption against extraterritoriality did apply here, it does not. The court should still apply Section 47.1 because the conduct relevant to Miss Lively's motion has a sufficient nexus to California. The Wayfarer parties principally argue that there is no such connection because the film was shot outside California and Miss Lively is not a California resident. This misses the mark. The relevant conduct here is the Wayfarer party's retaliatory litigation based on statements contained within Miss Lively's complaint to a California agency. not the sexual harassment and smear campaign allegations underlying Miss Lively's affirmative claims. Okay. The relevant conduct here is retaliatory litigation based on the statements. Dude, no. Absolutely not. No. I mean, I don't know how that's going to play out, because it's something where, like, you could set forth the argument that way and they might agree. The judge might agree with that, right? But then you kind of say, like, okay, but we all know that's not actually what happened, but you can't actually prove that. So I don't really know. I'm kind of fucked on that one. So this is frustrating. Okay. Like I said, we're going to skim through the rest of the extraterritorial stuff. All right. Factual findings as to Miss Lively's affirmative claims have no bearing on whether Section 47.1 applies. So, factual finding as to her, like, outstanding claims of harassment have no bearing on whether the Me Too law applies. Ma'am. I mean, this lady has more screws loose than a home improvement clearance bin at a Walmart. I don't even know what to say to that. The Wayfarer parties further assert that the court cannot rule on Miss Lively's motion until a trier of fact determines that Miss Lively acted without malice in communicating about the Wayfarer parties' sexual harassment and retaliation, and that Miss Lively had a reasonable basis to report her concerns about the workplace. That seems extremely practical. Miss Lively is unquestionably the prevailing defendant in the failed defamation action. The court's dismissal order, which holds that Ryan Reynolds, Leslie Sloan, and the New York Times did not act with malice, including because Miss Lively gave them no reason to doubt her version of events, only bolsters this conclusion. To insist Miss Lively reprove these facts at trial would cut Section 47.1 off at the knees. Okay, well, if it gets cut off at the knees in this circumstance, it's because it's not a good. I'm sorry, it's just not designed well. The California legislature made clear that Section 47.1 remedies must be made available at the earliest stage to prevent protracted litigation that would re-victimize complainants. Okay, well, she was never victimized in the first place, so I don't really have any sympathy for her. Forcing Miss Lively to endure a jury trial to establish what you're already going to a jury trial, you jackass. What do you mean? Forcing Miss Lively to endure a jury trial to establish what is already plain from this court's own rulings would run contrary to the statute. That's bizarre. She already has to prove that. Like, she's already going to a jury trial where she has to prove that. What do you mean? Nor do the Wayfarer party's attempts to muddy the waters by claiming that Miss Lively's Section 47.1 motion presents the same factual issues as her affirmative claims withstand scrutiny. Whether Miss Lively acted without malice to make her complaints is not a necessary element of her affirmative claims. It fucking should be. Jesus Christ. Miss Lively does not have to prove that she made a complaint at all to prevail in her sexual harassment claims? Oh, God. Oh, my God. This lady. I feel like she probably claps for herself when she enters a room. Like, what is this? She's giving the vibe of someone who would, like, set the toaster on fire just to see what happens. What are you doing? This is such a reckless disregard for people who need these kinds of protections. Holy shit. That is bizarre, dude. Good bitchin', lady. Thank you for becoming a new member. I appreciate it. That's a nice username. Okay. All right, let me just try to move on here. My God. Oh. That's embarrassing. Like, that's such an embarrassing thing to put out there. It's like people are questioning the claims that she's made so much because it seems like they're not really plausible, and the evidence that has come out is directly contradicting the things that she said in her original complaint. And so her arguments now that she doesn't have to do that, she doesn't have to prove that, she doesn't have to prove she made a complaint to prevail in her sexual harassment claims. Bro, like, that, again, I don't know how that's going to play out in court. All I can tell you is, to the public opinion, like, that is a nuclear bomb on your reputation right there. That is fucked up. Like, and of course, the mainstream media and all the magazines and shit like that, they don't do a great job of covering her fuck-ups. So who knows if it'll even get picked up. But at the same time, if it does, if that even like gets out there a little bit, like, oh my god, that's embarrassing for your reputation. Wow. Okay. The Wayfarer party's contention that Miss Lively must first prove her entire retaliation claim imposes an unwarranted burden on Miss Lively, especially where the Wayfarer parties have already admitted they believed Miss Lively made her complaints in good faith. And this is hilarious, by the way. So they're referencing a text exchange between Justin and Melissa, in which they both agree that Miss Lively genuinely believes she's right and that all of this is unjust. Okay, we're going to come back to that in a second. And this court has already recognized the strength of the evidence in favor of a smear campaign. The court has not recognized the strength of the evidence in favor of a smear campaign. That is absolutely patently false. What is your fucking problem that you continue to say that? In fact, it's to the contrary. Like, the court said that you didn't have enough of a basis to get certain information because she kept throwing shit at the wall and seeing what stuck. Oh my god. Okay. Anyways, this text message exchange where they're saying she genuinely believes she's right and that all of this is unjust. Okay, they believe that she's delusional, not that she's correct or truthful. They believe she's a fucking psycho. That's not something you want to brag about. Like, this is not going to help prove your point. Okay, I think, Jesus, this lady has main character syndrome and, like, she's lost the plot. It's not a good combination. She's like a legend in her own mind. I don't know. And everybody else is just like, what are you doing? You're a psycho. Like, she thinks she's like doing her big one with this, and she just looks insane. I think the moral of the story here is that being a louder, more entitled, and more incorrect bitch does not actually make you any more believable. That's like, see here, to prove my point, you can see these text messages between these two people that I basically victimized and am trying to retaliate against, and they say that they think that I totally believe that I was right. Yeah, dude. They think you're crazy. They think you're nuts. They don't think you're correct. Like, what are you talking about? That's not a flex. Oh my god. That's amazing. That is amazing. All right. Miss Lively is entitled. I'll agree with him on that one. Miss Lively is entitled to actual treble and punitive damages. Finally, the Wayfarer party's contention that the court cannot award treble damages because Miss Lively has not yet established her actual damages fails. Jesus. I'm sorry. I'm still thinking about this text message. They actually just tried to cite those texts as evidence there. Okay. This is going to take me a minute. So remember when she dismissed her emotional distress claims because she didn't want to release her medical records? I said that I firmly believed that it's because she doesn't have any. Like, she doesn't have any records from going to therapy or anything because I don't believe she was ever in distress, right? But what if she had some records that said, hey, your therapist says you might be a little delulu. All right? So is it at this point, I'm like willing to believe that she might have let those claims slide because she didn't want people to know that she's actually a fucking lunatic. Like, what is happening here? Oh, God. Indeed, Miss Lively seeks a schedule for the submission of damages evidence, which the court may then treble under Section 47.1, and that would be disgusting, but okay. Further, contrary to the Wayfarer party's position, California courts hold that the judge or jury, as the case may be, has the authority to decide whether and what amount of punitive damages should be awarded. And that should go to the jury, in my opinion, but all right. The court is therefore fully empowered to determine the application of punitive damages at this juncture. If the court concludes that further evidence is warranted, Miss Lively seeks a brief evidentiary hearing on these discrete issues, which should be held separate from the trial on Miss Lively's affirmative claims to avoid confusing the issues or the jury. Okay. And to provide Miss Lively with the prompt relief the California legislature intended. The California legislature intended a whole lot of things, and you have completely defiled all of them. But all right, go off. That's it, guys. That's it. And of course, Ezra Hudson, who is on the board of one of the organizations that happened, to write an amicus brief in favor of Blake Lively and the 47.1 bullshit. Signed off on this. Nothing unethical going on there. All right. Listen, that was just fucking crazy. I don't even know what else to say at this point. But wow, imagine like arguing that you shouldn't have to prove that you did this without malice, and that you should get the money now, and you're like, I don't want to wait for trial because I don't think that I should have to prove it, because that's what this is giving. Whether or not, they can argue in legal speak all they want, but that's what this is giving to the lay person. Okay, and the lay people are making all the judgments right now. We're ways away from trial, if it even gets there. So holy shit. There's nothing else to say, man. All right, so I got to get back to finish a couple of things before I go to bed. But thanks everyone for joining me. Don't forget to hit the like button for me on your way out, and yeah, I will see you guys all very soon. I'm not sure if we have anything else coming up this week. I know they're busy with depositions and all that, but I'll keep an eye out and I'll let you know if I find anything. So, all right, thank you. Bye, guys.